I want to welcome everyone to the fourth in a five-part ACT project series on AI, large language models, and law. Past sessions have focused on understanding some of the basics about large language models, the implications of generative AI for law schools, and the implications of AI and LLMs in legal practice. Today, our focus is on LLMs/AI and judging, and we're very privileged to have Professor Tania Sourdin to speak to us about this today. She is the president of the Academic Senate at the University of Newcastle in Australia, and she is valiantly coming to us at 6:30 a.m. her time, so we have to thank her very much for that. She's the author of more than 140 articles, books, and papers focused on justice reform issues and has presented on a range of topics, including justice innovation, AI, and technology and law. She has a number of projects that have explored the use of AI in the justice system and the role of a human judge. Her book, Judges, Technology, and AI, was published in 2021. And I had the good fortune of actually hearing her present on a panel last year at the Law and Society Conference in Puerto Rico. And so was lucky enough to leverage that connection and convince Professor Sourdin to come and speak to us today. So she will speak, and then we'll have a bit of time for Q&A at the end. So Professor Sourdin, take it away.
Thank you very much, and thank you for that warm welcome. And it's still, no, daylight is here at the moment, so I'm kind of at the opposite end of the day. So please forgive me if I sound at all a little croaky this morning, my time. I'm absolutely delighted to be here. I join you on from the lands of the Awabakal and Worimi people, and I'm located in Newcastle, which is about 150 kilometres north of Sydney, surrounded by beaches on one side and wineries on the other. So that's where I'm joining you from. I'm absolutely delighted to be talking about AI and generative AI. And only yesterday I gave a presentation about generative AI in the education space. However, a lot of my work is with judges, and that's really what I'm going to be talking about today. I'm just going to take a moment and share my screen. It should come up in a second, and I will run through some content. I would like, if possible, to have some questions as well. So if you've got a question, I'll pause at the end and enable enough time so that I can hopefully respond to your questions. But if you've got a question on the way through, if you wish to raise something, please just let me know. I probably won't see your hand coming up if you're raising it because there's a bit to look at on the screen. However, do let me know and I'll try and follow up. So I'm talking about AI more generally, but with a specific focus on generative AI. And when I'm talking about AI, in a sense, I'm also talking about general technological developments that are impacting on the role and the work of judges moving forward into the future. So I'll touch on some of the more disruptive technological changes towards the end of my talk to really talk about the extent to which anticipatory ethics might assist us in planning a future, and given how rapidly the changes occur in terms of both Gen AI technologies and other technologies, I'm probably suggesting that approach which is more principles based, is very appropriate for the judiciary. Some of my comments come from the book that was kindly mentioned at the beginning. That book came out in 2021, and since then I've written a number of articles. Of course, I did use a form of Gen AI to write a piece of the foreword, and if you look at it now, it really doesn't make much sense. And it's a marker of how quickly Gen AI has moved to make more sense. At the same time, of course, we all know that it still hallucinates and makes things up, and it can be very inaccurate. And so I'll touch on that. There are many, of course, different forms of Gen AI. And we're now seeing the legal publishers produce forms of Gen AI that will be much more sophisticated than ChatGPT-4 or Claude or one of the other similar Gen AI. And I have to say it's quite a difficult area to look at internationally because the terms and conditions that relate to Gen AI use vary around the world. Your audience may not be aware of that, but I was recently in Europe and Claude, for example, was unavailable, and ChatGPT-4. There were different terms and conditions in relation to a whole range of things. I didn't do a very close analysis, but it was abundantly clear to me that some of the terms and conditions relating to confidentiality and security differed in different environments, in part because you've got a very different regulatory regime that exists. So technology is clearly reshaping the justice system and certainly reshaping what it is that judges do. And generally, I break up technological developments in three separate categories. So I talk about supportive justice technologies, replacement justice technologies, and disruptive ones. Those categories are useful for me because it enables me to think about the ethical issues a little bit differently because, of course, if you're completely replacing a judge, then the ethical issues are quite different and, touch on issues that might relate to the democracy and society as a whole. However, every single, if you like, form of technology raises ethical issues from a judicial perspective. And I'll touch on some of those today, as well as the use of some of these technologies. A lot of these technologies could be described as baby technologies, and most techno-futurists really predict that over the next 10 years, the changes will be much more significant than the changes that we've seen over the last 5 years, which is certainly saying something because Gen AI has, of course, been a massive disruptor and will continue to be a massive disruptor. But many judges are very concerned, for example, around other technologies, the use of deep fakes, how evidence may be dealt with. And also, I think, and I'll touch on it right towards the end, but the question of enhancing judges with neurotech. And that's non-invasive. There are a number of invasive neurotechs, but the non-invasive neurotech developments are very interesting. And they might, for example, encourage a judge to be more focused. And, some of these are already rolling out onto the consumer market now. So you've got the headbands in China that were used even 4 years ago with students, which would light up according to whether or not those students were focused or not focused. So they'd have a green light. A teacher could look out and see whether or not the students were focused in the room. And then you've got, the Apple earphone, which has a certain stimuli, which has been patented. But I think most people are familiar with Neuralink and Synchron and those other developments. Synchron involves a vascular stent, which is inserted into the veins, the vascular system in your brain, to encourage thought. But I'm not going to go too far on some of the more sci-fi applications that are present with neurotech. I'll start with today, and I'll talk about how the judicial system is responding to Gen AI. And again, I apologise if I miss some developments around the world, but it is a really rapidly changing area and it is quite difficult to track what's happening. Some of the sort of issues that relate to judicial take-up I will touch on, and those are issues, and I just completed a large-scale international study, and I led the study together with Brian Barry, who's located in Trinity College. But we had 9 different research teams around the world who interviewed judges through a survey instrument, and we had about 1,000 judges respond. And it was really asking judges about their experience and understanding of different technologies, and also really asking judges about what some of the barriers to technology take up were. And there was a survey of judges in Canada as part of that bigger project. And typically the obstacles to technological take-up were related to budget. And many courts have legacy systems, very poor and clunky case management systems. A lot of courts still aren't digitised, so the material that judges have to consider is quite limited, and that's very relevant, of course, when you're thinking about Gen AI and large language models. There's often little time for judicial training. There's a question about whether or not judges want to engage with some new technologies. And so there's an innovation readiness question. And for some judges, they're very reluctant to move into change. Some judges are very keen on Gen AI and others less so. And I think this is probably an issue in judicial systems around the world, in that it's quite hard for judges to collaborate and work as a sort of a cohesive force in relation to the development of guidelines and ethical standards for judges, because typically judges are quite independent and may not actually work as a force together. So there are obstacles there. So the supportive technologies, we know that in the justice system, we've got technologies that are informing, supporting and advising people, and there are different structures and supports that are available for litigants and also to some extent judges. But with the COVID changes, of course, we saw a huge increase in video hearings, remote conferences, and then there's this host of apps that are out there in the justice system as well that provide information and support and can help people move into a dispute resolution form. And of course, there's the more basic generative AI, and some courts have done a bit now with chatbots in particular, informing people on the way through. The effectiveness of those techniques I'll mention, and I'll also talk about China and the smart court system there. And then you've got some courts really looking at how they can use generative AI. And Singapore, you can see this article from last year, has really started to use Gen AI and embed it within a small claims tribunal setting. And so, these are interesting developments, and I think we can probably see more of these developments into the future. There is a tension there with the big publishers as Thomson Reuters rolls out co-counsel. There's a question about who has access to more specific Gen AI legal tools. And, this is an issue that I raise at the university as well. Do some law students have access to this because they have a subscription to it, and do some not have access to it? And it's the same with law firms, who has access to the better forms, if you like, of Gen AI. And they are getting exponentially better every day, although some of them still are pretty poor. If, for example, you've only got Microsoft Copilot and that's all you're using, then that's a very different support tool compared to something, which is specifically developed for the legal market in your jurisdiction. I've got to say the jurisdictional issues are quite interesting, in that in my own jurisdiction, a lot of the Gen AI, so if you ask ChatGPT for something, it's probably going to give you something which has more of a USA slant, and I suspect that that's probably going to be the case in Canada as well. For example, not using GPT-4, which was actually not so bad on this task, I asked Copilot to draw a picture of a robot judge for me last week, and we don't use gavels in Australian courts. And I gave a number of prompts saying, remove the gavel, without the gavel, in these pictures of a robot judge. And it was simply, Copilot was simply unable to do it. And after generating 32 images, I gave up and asked Copilot how I could complain about what it was doing, and got a very inferior response. I just mentioned that because it is one of the big issues that we have with Gen AI. Really, what data is it being trained on, and what do we understand about the data that it's being trained on, and the sort of bias towards, for example, some data. But the really key point was that it was unable to draw a judge without a gavel somewhere in that image. And, again, you really have to think about the cultural appropriateness of some of the Gen AI work as well. I'll touch briefly on, some of the other technological changes which are very interesting. The micro expression tracking will probably be developed alongside a lot of Gen AI. This is a photo of myself and a colleague having some micro expression tracking work done. And I have worked with judges with micro expression tracking as well. And it's very interesting around how these technologies might combine so that people who are involved in a court hearing have a very a different perspective of what's actually going on in the room. Again, some of these technologies are pretty clunky and not necessarily as accurate as they could be. However, they are improving in terms of accuracy. I do note, though, that some of these technologies, it would be extremely difficult to have these technologies in some jurisdictions. For example, in Europe, I couldn't use a micro expression tracking technology with judges because it simply wouldn't be permitted as a result of their regulatory environment. However, in other jurisdictions, there will be I think, a different approach and perhaps more scope for experimentation. And then you've got, the basic issues that arose, I think, over the COVID period with technologies that are supportive, like, Zoom, Teams, WebEx. And, these same sort of issues arise in relation to confidentiality and security with these technologies. But there are other issues relating to Zoom fatigue and focus on self, and this question about whether you get more bad behaviour. These issues are more specific to some technologies rather than others. However, the piece around changes in behaviour and whether or not, for example, a supportive technology or replacement technology like Gen AI leads to less analysis and less thoughtfulness in terms of the preparation of material is, I think, a really interesting one. I'm going to talk just a little bit about Gen AI and perhaps some of the Australian case law, and then turn to some of the international sort of issues. One of the big issues at the moment is the extent to which litigants and their lawyers actually indicate that they use Gen AI. And the first case up there of Youssef is a recent case in one of our jurisdictions where the lawyers actually indicated that they'd used Gen AI and used Gen AI in a particular way, and the court cited that as being approving this approach. There is a real question around whether or not a lawyer has to inform a court when they've used Gen AI. I think a lot of people would think no, that there is no need to do that. And then you've got the judges themselves using Gen AI, and you've got the response from really, the deputy head of civil justice saying, it's really useful, particularly to summarise. Now, I've got a little bit of noise going on in the background, so my apologies for that. I don't know if you can hear it, but I suspect that they're trimming a tree at the front of my house and making a bit of noise. My apologies. It's very early in the morning, given it's not even 7 a.m. now, but it's causing my little dog to growl in the background. So if you're hearing unusual noises, my apologies.
Tania, that might be a good opportunity. There was a note in the chat about whether you could elaborate on death via Zoom, which is sort of interesting considering what we're doing here right now.
Yeah, I did actually. I mean, there's Zoom fatigue, but I wrote an article on death sentencing via Zoom during the COVID pandemic, where 2 people have been put to death via Zoom. I'm sure that there were many others, and it really, I think, for me, raised lots of questions around the sort of, what is a human being and what happens when you, if you like, decide something via Zoom without having the person involved in it at all, and what supports were available to them. And it's a bit like operating a drone in that if you operate a drone and it goes and kills somebody, is that this sort of dehumanizing experience? And I think this is very interesting because, when courts do certain things with technology, does that actually mean that people have less trust and confidence in the court? Or to what extent are people in general, for example, prepared to accept a form of AI making a decision in small claims matters if there are cost and time savings? And then, really, how does this impact on the system overall? So I think it raises some really significant ethical issues around the role of courts and judges in our societies, and some of the issues that are raised with Gen AI, as well as these other technologies, relate to the independence of the judiciary as well. And I'll touch on that in a moment too. This use, though, of tools like ChatGPT by judges is a very interesting question. Of course, you've got the Schwartz case, the Matter case that I'm sure you've already referred to, and the fake citations and the issues that might occur. And then you've got a whole lot of different law society and other rules that often are linked to confidentiality that I think you considered in the seminar last week. And from a judicial perspective, these are very live issues. And so a lot of judges have looked to either sign into the GPT opt-out provisions, which are really not much protection in terms of confidentiality, or they're looking at building their own large language models, or waiting and seeing until the publisher tools become more widely available. And so I think there's a level of caution, unless they're using it, for example, to prepare a case summary, which of course can be quite useful so that people understand what's going on. Judges may also be using ChatGPT or some form of Gen AI to generate policy, and that's a whole other field, that law as code field. And there's currently I think a lot of controversy over the law as code use, that is the use of Gen AI to create legislation. And I know that there was a recent example in Canada where I think some legislation, there were something like 20,000 amendments that were proposed that had been generated by Gen AI. And yet, on the other hand, you've got Susskind in the UK saying most of the legislation will be produced by Gen AI into the future, and it's incredible. So I'm sure that there will be a real division in terms of the utility of Gen AI to generate legislation. However, a lot of this does end up with a law as code argument, and of course, once you've got law as code, there is a suggestion that AI can then be used to determine more outcomes in certain types of cases. There are generally perceived to be some carve-outs. Administrative law is a very difficult area in terms of carve-out, and I think many jurisdictions have faced some horrendous issues with the use of automated decision-making in the administrative law area, which generally has disadvantaged the most vulnerable people. So there are significant issues there. Family law is another carve-out area where it's considered that, yes, forms of AI can be quite useful in relation to giving people an idea about what they might expect if they continued on to a court hearing. But the integration of Gen AI into a court process isn't perceived to be useful, in part because there's a focus on the relationship between the couples and the ongoing parental relationship, which arguably requires some human touch. And criminal law is also a kind of a contentious area, partly because of the Compass Loomis issues that have loomed large. However, it seems to me that it's inevitable that we will have forms of AI being used to determine small cases, small debt cases, contract cases, and particular categories of cases, particularly if the litigants actually opt into a AI determination. Generally that will be on the papers until the voice to text transmission improves. in terms of accuracy, because at the moment it's still quite inaccurate. So far, you know, the guidance for judges in terms of Gen AI more specifically have varied a bit. And I'll refer to the New Zealand guidance in a minute, but the Europeans have generally sort of talked about, you know, the general Gen AI issues, intellectual property risk, data protection and privacy, cybersecurity, training data concerns, output integrity, ethical and bias concerns, and the human resources and reputation risks. These are more specifically for judicial officers. And if you look at the report of the European Commission for the Efficiency of Justice, they've actually considered this more specifically in respect of judicial professionals. So there has been some direct attention paid, if you like, to judges in Europe, less so in other parts of the world. And really, Europe has the most sort of collaborative examples of Gen AI. And then you've got guidance for judges that really varies. And this is an example from New Zealand, where the guidance for judges in terms of disclosure of Gen AI use is that judges don't need to disclose where they've used Gen AI, and the clerks and researchers and judicial support staff should be discussing it with their supervising judge. Now, I don't know what people think about that. And it is quite I think, an interesting question around whether or not a judge has to disclose the use of Gen AI. In a sense, judges don't disclose where they've had a researcher prepare material. And so why would they be disclosing where they're using Gen AI? Yet on the other hand, I think a number of people might be quite concerned about the use of Gen AI by judges. And there is this, I think, open question. New Zealand is around the only jurisdiction where I've found that there is that clear rule about not disclosing, but I might have missed something in Canada. I was there last year talking with judges, and it may be that you've got a different framework that now operates. So, Jane, I don't know whether you know of anything further in relation to Canadian judges.
I don't know actually. That's a really good point, and this is the first time I'm hearing about this guidance from New Zealand. We did have a comment in the chat actually earlier that for transparency and confidence in the judicial process, all participants should be disclosing whether they've used Gen AI to prepare pleadings or demonstrative examples, and that was even before we got to judges using them. So it's sort of a sense that all of that should be, at least from one participant, that all of that should be on the table.
Yeah, it is an interesting question, and it's an interesting question in a university environment as well. I ran an ethical dilemma yesterday with some of our staff where a policy had been created by a staff member with Gen AI, and that hadn't been disclosed. And I asked staff whether or not they thought that was fine, and I think many staff thought that that was absolutely fine and it was an appropriate use of Gen AI and we should be using it more and more. Whereas others said, no, look, it really should be disclosed. If academics are required to disclose the use of Gen AI, then everybody should be required to disclose the use. And then I think there are some who have the view that Gen AI use will become so widespread into the future that you're more likely to have to disclose where it's actually written entirely by a human without Gen AI. And then there are the sorts of tools that are pretty simplistic, whether if you're using Copilot and it's correcting and it's drawing your attention to particular resources, then, you know, do you need to disclose that use? And so I think this issue is really going to be a pretty important issue for judges going forward. And again, it does come back to that, I think, interesting piece of work about whether or not they disclose that a researcher or a clerk has been involved in the writing up of reasons for judgment. So it's I think a hot button issue. I've only seen really New Zealand coming out to say quite clearly that you don't have to disclose the use of Gen AI, and I would anticipate that there will be different approaches to this and different understandings about this depending on the level of the court, and also I think depending on the way that judges have taken up Gen AI. So there is that bit of guidance around there. We've got, I've put Gen AI as both a replacement as well as a supportive technology. There is this real capacity though, in particular for Gen AI to write policies within courts to change the way court rules operate. And there are some quite sophisticated apps out there that are currently being used by litigants. And there's a question about whether they could also be used by judges. And again, that disclosure question is there, as well as the significant confidentiality and security issues. I've wondered in some of my writing more recently whether people care far less about confidentiality and security issues than they might have in the past. When the various forms of video conferencing were rolled out somewhat urgently during the COVID era, there were significant confidentiality and security concerns, yet people appeared to be ready to waive those concerns on the basis that necessity required that they use Zoom and other tools to video conference. And those issues still exist in that there are still concerns around security and confidentiality, but many people appear to have just considered that that's the cost of operating in this new tech-enabled environment. So I think these are interesting questions around where we might go. I've included this photo about where we might go because one of the questions that has been raised as well is around the use of avatars and robots. This is a somewhat amusing photo. I was traveling through Japan a few weeks ago, and I stopped off in a hotel which is completely robot operated. And when you check in, you've got this robot girl and a robot dinosaur. Why you have a robot dinosaur is completely beyond me. But I suppose I'm showing you this photo to say, look, what does it look like when you go into a court? What will happen from a registry perspective? Will we have these kind of very different registry experiences? Most courts have really shifted to an online filing system, but if you actually go into a court, what are you going to have? And I think the dinosaur is a funny example of that. And so these kind of replacement technologies, to what extent will they replace people throughout a court system, not so much judges. And then, you've got these apps, and one app that I reviewed a few years ago now, but I've sort of checked in on how it's been going for a while. Really, you've got as part of it what's called paralegal AI and accounting AI. And what the app does is gather material from banks with a consent. It paginates that material. It can create options. It can track where expenditure has occurred. And it can assist, for example, in a divorce application, working out where and what sort of contributions have been made over the last 5 years and what could be possible into the future in terms of expenditure. These are really interesting apps because these paralegal and accounting apps really are collating material and interpreting this material. And again, for judges, there's a capacity to organise material, particularly in more complex cases, in a way that probably wasn't possible in the past. And then you've got, these developments in places like China, and this is slightly out of date. And I am working on this with a Chinese scholar. So I'll have more up-to-date figures probably in about 6 months' time once we've completed some work. But it's an example of this micro court where, in essence, what you do is that you conduct the entire litigation process on your phone. And it all takes place using your mobile phone. And again, millions of matters that have already been dealt with, and many of them in less than 15 minutes. And this is this kind of piece where you're really not engaging with a human, but you're in fact engaging with more sophisticated form of AI, which again raises lots of ethical questions. In China, those questions are a bit different because judicial independence is regarded, I think, quite differently, and the role of the executive in creating these tools is also regarded quite differently. There are, a separation of powers doctrine. It doesn't exist in the same way in some jurisdictions, and I've always had a bit of a concern that some innovations from some jurisdictions might just simply be transplanted into others without actually considering the impacts on a democracy and respect for the court system and how it is regarded as being independent. And this is a hot topic even in relation to Gen AI, because the big question there is who creates and monitors and if you like, envisages the future of these forms of technology. And oftentimes you have courts, and then you have an executive which controls the budget and to some extent may control the extent to which you can have innovations. And if the executive is really looking after the data sources and also is involved in the development of the technologies, then there is an impact on judicial independence. So you've got the more simplistic forms of Gen AI, which are helpful for judges. This is like an expert system with decision trees that I had built in the early 2000s. The big difference, of course, with a lot of these forms of AI now is their capacity to mine data and produce material without actually having to have to consult with experts. And this raises issues about how humans are involved in the original design of some of these technologies, and not just humans, but judges, if you're thinking about it in the judicial sphere, and how judges monitor what happens with some of these technologies. And then we've got the more disruptive technologies, and they're really likely to be the ones that have a significant impact in the next decade. And you can see that with neurotech, where billions and billions of dollars is being spent at the moment on neurotech solutions. And a lot of those are non-invasive. So they're technologies that are designed to, if you like, encourage you to focus. They're technologies that will have an impact on depression, on Alzheimer's, everything else that we can think of. And there are questions around, if you have a judge that's been enhanced, what does that mean from a judicial independence perspective? And I think this is a very interesting question. And again, we're probably a few years off the enhanced judge, but when you have the development of stents, for example, that can be placed in the vascular system of your brain and prompt you to, for example, consider options in a different way, then there is a real question around, again, judicial independence and what it means when you have these forms of enhancements. And then we've got the big issues that I think are arising for judges because of some of these disruptive technologies, and the deep fake technologies are probably the ones that are going to have a huge impact just in the next couple of years. And some of you may have seen that article in The Guardian where essentially you can pay $5 in China and a form of AI with 15 seconds of video will actually create a replica, a clone of your deceased loved one, and they can talk to you and engage with you. And these questions are going to be enormous. I think there's a lot of international work trying to ensure that deep fakes are noted, that you can't put something forward as being, a real person if in fact they're a deep fake. But there are lots of opportunities, I think, for confusion in the justice system. And I said to our Chief Justice in New South Wales recently, I could have built a deep fake of him. I wouldn't, but I could, just by looking at some of the YouTube video work which appears in relation to in-court proceedings in Australia. And then you've got a whole lot of sort of ADR directives, which really are focused also on using Gen AI to help consumers in different sorts of ways. And some of these guidelines that have come out more recently are promoting Gen AI in the dispute resolution area. And I think inevitably you'll see that that has a further impact on court systems. And then you've got all these different European examples that are occurring as well, lots of pilot projects. And there's a fabulous EU Commission paper in 2022 on innovations, which goes through some of what's happening with in Spain and in Italy. And again, some of that is predictive algorithmic work, and some of it is this kind of predictable guidelines, but some of it is also really around producing template judgments for judges. And you know, I've raised concerns before about this, because in a very busy court, you know, is a judge less likely to question a decision that's been generated by a form of advanced Gen AI, for example, because they simply don't have time to review it, or because, of course, with Gen AI, it appears very certain and authoritative until you actually drill down into it. And then we've got the kind of AI developments that we've seen in China, which would be unacceptable in most jurisdictions, where you have what's called an abnormal judgment warning. That is, if a judge appears to depart from what is, if you like, a sentencing or another requirement, then the system automatically sends a warning to the judge's superiors. Now, I think in most jurisdictions, judges would regard this with horror, especially where you have an independent judiciary. And it really is this kind of judicial supervision piece in terms of AI. And again, I think some real challenges from a democratic perspective, as well as a judicial independence perspective. And I think these are very interesting, as I said, developments in some jurisdictions. And the question of the extent to which they'll be transplanted to others is a live one. And there's some other material which I think is interesting around the automation of judicial decision-making, and whether parts of that decision-making process can be automated and other parts not automated, which again, I think judges are engaging with, but often don't really have the time, I think, to engage with some of these questions in a way that is required really for our new future. And then we've got, of course, the whole notion that there'll be the death of law, and that the rule of law will be affected. And I was talking about something yesterday, and there's a prediction that there'll be no work that is original within the next 5 years, because as we increasingly use Gen AI and we have sanitized information, you know, innovation will cease in a sense, and that there will be less scope for innovation in terms of judicial work. And so for common law systems where judges do make law, this is a very serious impact. So I think from an ethical perspective, and I'll stop fairly soon to take some questions, you really have to go back to, you know, what are the underlying objectives of justice? What are the underlying objectives of the judicial system? And really consider some of these technological developments in the context of those underlying objectives. And, you know, when we consider that, we have to consider those broader questions around democracy and big tech, and, you know, what happens when you've got the databases being owned by, you know, entities or corporations. And there are already issues emerging around the capacity of newer tech companies or tech solutions entering the market. And you can see that in Europe, in a sense. You know, there's a concern that as a result of over-regulation, the only tech companies that can really be involved in the tech changes into the future are the really big tech companies, because they're the only ones who can actually afford to respond to the regulatory environment. And all of this is also, you know, there's a social equity piece in terms of, you know, whether or not you've got these economically powerful organisations Same issues with big firms. I mean, many of the big law firms have, of course, set up their own Gen AI systems and governance systems. And if a smaller law firm is, if you like, running a case against a bigger law firm, the question of resourcing has always been an issue. However, is that issue even more pronounced as a result of the Gen AI advantage that might be there? And then you've got sort of this issue around, look, is it actually useful to have some ambiguity in law anyway? And does that help us in terms of, struggling to find an answer, which is, I think, part of the human condition. And so I think that there are these kind of issues around privatisation of justice as well. And a lot of governments, particularly in the post-COVID era, have been very concerned about budget implications more generally across society, and justice has not fared well in terms of budget allocations in general, I think, around the world. And so there are, I think, some really direct threats, because if it's suggested that some of these tech approaches are considerably cheaper, then there is a real focus on the extent to which governments may decide to change and shift budget allocations. And just touching on neurotech, again, the non-invasive neurotech doesn't have to look like this. It can be quite simple, and I think the Apple, patent is a really interesting example. But some of the more simplistic neurotech will really change and adjust our understanding about what a human being is. And although some of those changes are likely to happen, 10 years and beyond, some of those changes will impact on human judges in the short term as well. So from an anticipatory ethics perspective, I've tended to look at this with levels of abstraction when I've attempted to look at it from a judicial perspective. It's not enough to simply look at the impact, for example, on the individual. You need to consider the interpersonal, group, institutional, sectoral, and societal impacts. And so from a judicial perspective, we need to consider, if you like, the ethical issues from this much more abstracted level. And I've tried to map 3 concern areas. There's the technical concern area, there's the kind of process concern area, and there's the human-centered concern area. And I think that this is, important in the context of risk assessment tools that might be developed by the judiciary. And I think that there needs to be these kind of risk assessment tools. And there's some very good ones around for business operations. I think the primary piece, though, is in relation to the judicial system, we have to kind of consider a range of other factors as well. We have to consider human dignity. We have to consider the role that a court and a judge plays within our society. And we have to consider, I think, these kind of broader impacts. And judges can't sort of not consider some matters. For example, sustainability as a question, in the context of this data is often not well considered. And if you ask ChatGPT around how and what impacts it has on the environment as a large language model, you don't really get a full picture. You also don't really understand that, I think, a lot of the work that has taken place creating much of the Gen AI has really, or could be said to be, modern slavery. If you've got thousands of people being paid less than $2 an hour to actually curate a lot of the material. So I think these are important questions, and what I'm really suggesting is, I suppose, a framework that I'm talking with judges about, to really say, look, it's not just about the individual and the individual litigant. It's much broader when you consider the justice system, and we need to consider it within these 3, if you like, concern areas: the technical concerns, which are often talked about, the process concerns, which I think are a bit different again, and I think the human-centered concerns. And so I've finished, and hopefully some people have some questions.